Yep, it just started now.
Sounds good. Thank you. All right, welcome to the GRadulting Workshop Series. My name is Debbie McCutsky, and I'm the coordinator of services and programs for graduate student legal aid. I use she, her pronouns. Today's workshop is co-sponsored by undergrad student legal aid, and I am being assisted by Michael Marino. He is the grad assistant for their office. I also want to welcome Cindy Schilling. She is the attorney and director for undergrad legal aid. So thank you both for being here today. So we're happy to see lots of folks here with us on Zoom, and I know you'll be watching us on YouTube. Today we're going to learn about job contracts. And I hope this means that you have a lucrative and generous job contract in your future. So before we talk about that, I want to remind you or tell you a little bit about the legal aid offices. We do serve both graduates and undergraduates in separate offices that work closely together. We do things like if you have a legal issue, you can talk with an attorney. You have a legal immigration issue, we have that here too. When you get charged by the Office of Student Conduct, we had advocates to support you through that process. If you need a notary, I'm a notary, and Cindy, the attorney, is also a notary. And if you've paid your student fee, you've already paid for this service. So we're here to help you. We want to be busy. We are a great resource. And if for some reason we can't help you, we will often be able to refer you to someone who can. So take a look at our websites. We'll put that in the chat later, and you'll learn more about exactly what we do and how to schedule an appointment with us. So just a little bit of housekeeping. Automatic closed captioning has been enabled for those who want to read along. Near the end of the workshop, I'll post a link in the chat for a survey because we need your feedback. We want to know how we're doing with these workshops. We will email links to the survey, the slides, and the recording after the workshop. We want to make that easily accessible to you. So, and as for your questions during the presentation, feel free to post them in the chat for everyone to see. And I'm sure we'll have enough time to answer your questions. So I am so pleased to welcome back and introduce our speaker today. Her name is Joyce Smithey. I'm going to brag about her for just a second here. She is a highly respected employment and labor law attorney. She represents employers and employees throughout Maryland and the District of Columbia. And she's got more than 22 years of employment experience. And she brings a wealth of knowledge to helping clients cost effectively protect their interests in administrative hearings, state and federal litigation, and in her day-to-day practice. So I can't thank you enough, Joyce, for making time to present this workshop again. You have been doing this since 2018, and it's so good to see you again. Please take the stage.
Wonderful, thank you. It's as I was saying before we started, it's always fun to do this because a lot of my job is dealing with employment relationships at the end when they go wrong, and this workshop is about the beginning. And again, hope everybody's getting lucrative contracts out of this, and tuning in because it's the beginning of a wonderful relationship. I think we're going to have a PowerPoint posted in just a second.
Yep, I'm working on it.
My background is employment law. That's all I do. I'm a one-trick pony on employment law. I own and run an employment and labor law firm out of Annapolis with 9 attorneys, Smithey Law Group. My contact information will be at the end. Next slide. So what is an employment contract? A lot of people call me and say, oh, you know what, I don't have a contract though. It was just a handshake and it was verbal and oral. Doesn't matter. It can be a document that both parties sign. It can be an oral agreement. It can be two parties discussing what they want to do and making an agreement on the terms of the employment relationship. It can also be implied from handbooks, actions. The law on handbooks varies from state to state. I practice in Maryland and DC primarily. So generally handbooks, if they don't have a disclaimer in the beginning saying this isn't meant to be a contract, if they don't have that disclaimer, they can themselves form a contract with you about your employment relationship. Next slide. Okay, what is the covenant of good faith and fair dealing? Every contract has an implied covenant of good faith and fair dealing. What does that mean? It means every party is agreeing that they're going to come and perform their obligations under the agreement in good faith. So sometimes when you're saying, you know, they're doing all these things to make me quit my job, I can't figure out exactly where the breach might be. In some states, you can have an independent cause of action for a breach of the covenant of good faith and fair dealing if they're not behaving in a good faith way in their relationship with you. Next slide. Okay, so when do employers want a contract? Only about a third, maybe a little less of employees have contracts. The general state of employment law is that the majority of employees are at will, meaning they can be fired at any time for any reason other than Montana. Montana's the exception. They don't need good cause to terminate you. And so that's the majority of our employees out there. So employers sometimes want to have a contract. A lot of times when they want to have control over your ability to leave. We see this a lot with like nurse practitioners, people supporting the medical fields, and they want to control this person's ability, you know, to be able to just walk out, because at will is a double-edged sword, right? They can terminate at any time for any reason, but so can the employee. So sometimes they want certain notice, right? It's going to really affect our business. You need to give us 30 days notice, 6 months notice. And so a lot of times they do it to limit the flexibility. But of course, that means that's limiting their flexibility on how easily they can terminate you as well. If you have access to confidential and sensitive information, they're likely going to want a contract with you. If you're dealing with, you know, the trade secrets of Coca-Cola and you've got the formula, they're going to make you sign something for that. People who have access to customer information, things like that, they're going to want an agreement to protect those trade secrets. Non-competes, we're going to cover that. Those are very, very hot topic right now. We'll talk about those. And it can give you job security, right? You could get a 2 or a 3-year contract that changes the at-will relationship and says it can only be terminated for certain reasons. Also, like senior managers, high-level employees, it's more common to see a contract provided in those situations. Next slide. Do employers have to offer a contract? Absolutely not. I get calls from people saying they didn't even offer me a contract. I want to sue them. They do not have to offer a contract. Next slide. Okay. So we're going to go through all of the different parts of an employment contract. I can't tell you how many people I meet who just sign something and they say, well, it was all legalese. So I didn't bother to read it. I figured I didn't understand it. So I just signed it, and they have no idea what they're signing. We're going to go through the different clauses you're going to see so that you can understand what you're signing, talk about areas where you may want to negotiate some of it, where it can, you know, lead to problems. Duties and responsibilities is almost always the lead clause, talking about, you know, what you're going to be doing, your job duties. There's a best efforts clause. Many times, all that means is you're agreeing to give the job your best efforts. the get copies of all documents referenced within the contract. This is a big one. I can't tell you how many times I meet people who don't do this. If you're agreeing in a contract to follow things like policies and handbooks, or you're agreeing to accept stocks under their stock, agreements and plans, get copies of those. You want to be looking at those. If you can have your contract, if you could breach from not following the policies and the handbook, you ought to get a copy and know what's in there, because you're going to be held to it. A lot of times there'll be references of you'll get the benefits as, whatever is in our current benefit plan. Get a copy of them, know what you're entitled to get. Sometimes there will be references to other agreements that you may have already signed. Sometimes you start and they have you sign a trade secrets agreement or an intellectual property agreement. And then when you sign the contract, they reference it. Get copies of it. You want to know everything that you're going to be obligated to follow and they're obligated to provide. Next slide. So compensation. This is going to be what are you getting out of this employment contract? It may say how often you're paid. That's regulated by state law in many places. Sometimes you have to be paid every 2 weeks or at least twice a month. Bonuses. Pay attention to what it's saying about bonuses. A lot of people call and say, hey, I didn't get my bonus. And if it says it's discretionary, you're not going to get it. If you believe you're entitled to a bonus, make sure that's spelled out in your contract. Profit sharing, stock options. Again, they're going to reference a plan for their stocks. Get a copy of it. Know when you vest, all of those things. I talk to a lot of people who plan to leave their employment and aren't even thinking about the fact that they may have tens of thousands of dollars of stock vesting, in a few months. So make sure you understand those. Expense reimbursement, moving expenses, any of those all get spelled out in employment contracts. So this is just a handy list to think about. Hey, should I be getting these things? And if they're not spelled out in the contract, it's a good idea to ask a question about them. Next slide. Benefits. A lot of times we see a reference saying you'll get the benefits, that are spelled out in our handbook. Get those documents. Health insurance, there's a world of difference between low-level health insurance plans and the PPO, where you get to, choose your own doctors, things like that. Find out what they have, find out the vacation and sick leave, all of those things, retirement accounts. Get the plan documents, right? That's going to tell you what your rights are in those. They do usually reserve the right to change their benefit plans. That's allowed under the law. And so if you see that, don't be alarmed. That's normal. Employers reserve the right to switch what they're doing, change health insurance plans. So that is a very normal thing to see. Payout of vacation upon termination, that's also regulated by state law. I'll give you an example. In Maryland, it must be paid unless they've expressly told you in writing ahead of time that they don't pay it out upon termination. So a good idea to look at what they're going to do. What you don't want to do is have 6 weeks of vacation, quit, and you realize, oh, I should have used that during the year because I'm not going to get that back. Next slide. Duration term. This is a really important thing to look at. It could run for months. This is a 6-month contract. Years, I see 3 years, 4 years, or indefinitely. A lot of times it'll have an auto renew clause, right? So look at that. Is there a renewal specified? This comes up all the time where somebody calls me and what they don't realize is it's a 1-year contract, but it auto renews unless somebody gives notice 30 days before the renewal. And so you get this window for 30 days every year where you could leave. And if you miss that, you're back into a year contract. And so I even tell people, if you're even thinking you may take another opportunity, pay attention to auto renewals and mark it on your calendar so that you remember, if I don't tell them I'm leaving, I'm here for another year. So pay a lot of attention to those, how it does renew and the notice periods related to it. A lot of people get stuck in contracts for longer than they meant to because they didn't pay attention to the auto renewal. Next slide. No authority to contract. This is another thing that people just look at and say, sounds like legalese. They're likely to say that you don't have the right to enter into contracts. That's to keep you from going out and telling somebody you're going to buy $2 million of parts for something and not getting it cleared. So very normal part of contracts that you should expect to see. Next slide. Exclusive employment. This is a big one, especially because some of you may be doing research assistant work still, stuff like that. If there is a clause, and there's nothing mandating it, it's an employer choice. There's nothing illegal about moonlighting or taking two jobs. But if you agree to exclusive employment, that you're not going to work for anybody else or anyone else who has a same or similar business, pay attention to that, because it can matter, right? If you're doing research on the side, for example, I get contacted for people about that very issue. Hey, I just signed with a hospital and I really want to do some medical research on the side, but I have this clause. If you have that, you're not going to be allowed to do it without renegotiating your contract. It's not as common, but you can even see, we do see the contract saying you can't even be a shareholder in a competitor business. So take a look at that so you don't stumble into a breach without knowing it. If you hold some stock in, Google, for example, and you're interviewing with one of its competitors, that could come into play. Next slide. At-will agreements. This is what I referenced before. This is the status of employment law in all but Montana. The idea, again, is you can quit at any time, fired at any time. They don't need to have good cause. The example I hear all the time saying, I don't like the color of shirt you're wearing. And people say that's ridiculous and unfair. It is, but it's not illegal. They don't need good cause. You're going to see employers, because this is such a powerful doctrine for employers, you're going to see them reinforcing this everywhere they can. If you're going to be an at-will employee, you'll see it in your offer letter. Hey, we're offering you this employment, but it's still at will. We can terminate you anytime we want, with or without cause. Handbook acknowledgments will again reinforce this if you're an at-will employee. Next slide. So termination clauses say how can they get out of the contract, right? So even if you have a 3-year contract, there's usually going to be some provision for how to get out of it, usually on both sides. And it may be that there's different ways they get out of it if it's a for-cause termination versus without cause. There can be notice provisions, simply, hey, either side can get out of this with, say, 60 days notice, right? So it's a modified at-will employment in the sense that we can get out of it for any reason we want. We just have to give 60 days notice. Sometimes you'll see cause triggers, such as you violated the contract. This particular clause tends to be one that people fight over a lot. And so pay attention to it. Most companies, if you're fired without cause, it triggers some sort of severance obligation on their part. And if it's for cause, it usually will have no payments due. And so a lot of times employers will manufacture some allegations of cause to get out from paying substantial severance. So pay attention to what they can use as cause for getting rid of you, because know those things. I always like to negotiate an opportunity for a cure. So if they're going to say, hey, you violated the contract, you didn't fill out this paperwork that you agreed to do, have an opportunity to cure, meaning we can only terminate for cause after we give you like 30 days notice for you to fix this problem. What that does is, A, gives you an opportunity to fix it, but if nothing else, it gives you some notice that they're coming after the contract and trying to get rid of you. Gives you that window of time to talk to a lawyer, start looking for other jobs. So try to negotiate in this part an opportunity to cure, both to give you notice and that opportunity to improve. Disability and death clauses are very common. They may seem very morbid, but they are common and they are out there, spelling out what's going to happen to an employment contract upon your death. It'll define disability. Usually they echo FMLA rights, which are 12 weeks. If it's an employer of at least 50 employers or more, and you've been there a year, FMLA gives you 12 weeks of medical leave. So you usually don't see it less than that. But I've seen them as much as 6 months before it triggers the disability clause. Good to look at. If there's a death clause, it will usually say that the rights don't transfer to your heirs. If say, for example, there's a huge bonus or something you want transferred, you need to talk to them when you look at that clause and make sure, that certain rights can transfer upon death. Discontinuance of business. This is one where you're going to want to look, are they giving severance? What's going to happen at that time? Is there notice? What's going to happen if they go to a merger or an acquisition? There's also a return of property clause. These days, a lot of laptops that belong to the company. It's also intangible property, right? If you've got our intellectual property, our trade secrets, our documents, we want that all returned. We don't want any in your possession. Cell phones, there'll be a return clause for all of those things, keys, all of that. So, that's what that means. Keep an eye on that. Remember that, you will have to return these things at the end. Next slide. Severance provisions. Next slide. So let's talk about the severance provisions just a little bit. I talked about that already. These are the provisions that if you get fired without cause, what do you get? And they'll spell out what severance you're going to be paid. And it varies, right? Most states do not have a mandatory severance obligation. And so having it in your contract is really important. Because there's not going to be some other law you can point to saying, hey, I'm entitled to severance. And it runs the gamut. I've seen them run from just a few weeks, no matter what, to some that do, 1 week per year is a very common formula to see. And it sort of tops out where I see 2 weeks per year, but maxing out around 6 months. Higher executives may go higher than that, but take a look at what you're getting during the severance period. Are they paying your COBRA for your health insurance during the severance period? Things like that. Are they matching your 401k still? Things that are going to really matter to you if you lose your job. So take a close look at what you're getting there. And it all may be negotiable. Hey, I don't see COBRA addressed. That's your right to have your health insurance continue after losing a job. And a lot of times it's common to see the employers paying for your share of COBRA in a severance provision. So take a look at that. You may want to negotiate that in there. Protection of trade secrets, confidentiality agreements. This is in almost every contract I see. You already have an obligation to maintain the secrets of your employer through the Trade Secrets Act. Most states have a version of that. There will be something in there saying anything that we consider confidential, that we're taking efforts to keep password protected, aren't out there in the general public. You're agreeing to never provide that to third parties, never use it. That is very common. It would be unusual for you to get a contract that doesn't have that clause in there. It is also one that they are usually very loath to negotiate because they want those things protected. They're going to echo the Trade Secrets Act language usually. You're going to be obligated anyway. So while it's usually a long paragraph and very dense, it's one that's usually not negotiable and one that you're already obligated to under other laws. Next slide. Evaluations. I see these in probably like 3/4 of the contracts that state how you're going to be evaluated. There is a trend with some companies moving away from evaluations, but a lot of them will promise it in the contract. Just take a look at that. You'd be surprised how often that's the breach on the employer side. And it sometimes gives me an argument when I get a call from someone saying, hey, there's been no problems whatsoever. I would have had $100,000 severance package, except for they just made up this thing that I wasn't performing. And then I find out, but they didn't give you the evaluation as they promised in the agreement. We get to come back and say, then you breached first, and that deprived my client of an opportunity to hear anything about performance. So it can be advantageous to have them agree to give you regular evaluations. It keeps you informed of how you're performing, but it's also gives them an obligation to communicate with you so you don't get surprises. And if you get in a very comfortable relationship where they're forgetting to give those, it can protect you if they come out of nowhere with a termination, that's fabricated because of financial stress on the company's part. Next slide. Okay. Ownership of work product. This may be really important for some of you, right? Inventions, books. There will usually be a provision in there about work for hire. Anything that you're doing on the employer's time is theirs, right? So be careful. If you've been working on an invention or getting something patented or working on a book, usually you can let them know and say, I want this carved out. I'm not going to work on it on company time. Carve it out, because if not, if it's created during the time you're an employee, generally there's going to be a presumption it's a work for hire and they own it. And so it's common for, especially when I work for like Google executives doing their contract, they have an addendum sometimes that just lists all these things they're working on the side. So be careful if you have any kind of IP, intellectual property. Usually there's an agreement you'll cooperate in getting patents for any of the work that you've done with them. Next slide. A lot of times there'll be a method for how you're going to resolve disputes with your employer. Arbitration is very popular for employers. It favors employers. It does not favor employees. When you study the statistics, arbitration skews heavily in favor of companies and businesses. Juries tend to be more favorable to individuals. That said, this tends to be something they are not willing to negotiate. Even when I get involved negotiating high-level contracts, we have a really hard time getting them to change it. So just be aware when you see it. You're giving up your right to court, a jury trial. It's not favorable. That said, until a law passes eliminating that, you may be stuck with that. It may be binding, so you won't have any appeal rights. You get this one arbitrator to come in and hear things, and you're stuck with whatever decision happens there. Take a look. A lot of times they have procedures for how you get to select the arbitrator, depending on the rules that you're going under. So very common to see it. Employers love it. Not friendly to employees, but very hard to negotiate your way out of it. Next slide. Choice of law. So a lot of times they'll say your employment relationship is governed by X state, right? And there's no doubt that some states have more friendly laws. California, for example, has more employee protections than probably all the other 49 states combined together. It is a very employee-friendly state. And there are some, Georgia, for example, that are known as having almost, other than the federal rights given, they give no rights under the state laws. So take a look at what's going to govern your contract. For example, if it is governed by California, non-competes are illegal in California. So you're good on the non-compete law if they're going to govern it by California. So take a look at that. That's going to govern the relationship and govern any dispute. You'd be surprised how different the states are, and you can have something that's not a claim at all in one state, and in another state, it's worth a lot of money. So take a look at that. It's very common to see somebody working in Maryland and assigned to Illinois or something like that, where there's a headquarters. So take a look at that. Next slide. There's usually a remedies provision. This is very common, also tends not to be negotiable. They're generally saying we have a right to seek an injunction, which is the court's ability to order somebody to do something. So if you are out there giving trade secrets out, they're going to ask you to agree that they can go get an injunction against you to say, stop doing that. Or if you're competing against a non-compete, an injunction would be in order to say, don't do that. Again, very common, not something they're usually willing to negotiate out of in the contract. Next slide. Notice provision. This one is something you want to pay attention to. It comes up all the time where somebody calls me and says, oh yeah, I emailed them my notice that I'm going to be leaving. And the notice provision will say how you have to provide notice. It could be via certified mail or via a fax number, and it has to go to a specific person. And so as you develop close relationships and you think, okay, if I just send an email to my boss, I've given notice. If you get an employer who's really desperate to keep you, and we've seen this a lot in the medical field, especially if you get an employer desperate to keep you through a project or a deadline, and you give notice through email, they may come back and say it wasn't real notice. You're stuck in your contract for another year. I've seen it happen dozens of times, actually. So pay attention to your requirements. You can still manage your relationship by saying, hey, I wanted to let you know personally, just so you know there's a certified letter coming, because that's what my contract requires. But wanted to let you know in a more personal way. So pay attention to that, because what you don't want to do is accidentally get stuck in a contract that you meant to get out of, during a renewal period. Next slide. Representations and warranties. This is where you're representing to the employer certain things. The big one you're going to see is usually they're going to ask you to say you don't have any other non-competes. That's to protect them. They don't want to get sued for hiring somebody who has a non-compete, because the employers get dragged into this under a theory called tortious interference. So they're going to ask you to warrant that. Don't panic when you think, oh my gosh, I have one. I'm never going to get a job. In your fields that you're likely going into, they're very common, and it's hard to hire people who don't have them. Just disclose them. Disclose. If it can be worked around, I would say about 50% of the time they're overbroad and not enforceable, and their lawyers will look at it. You can hire a lawyer to look at it. But it's a reality of the world right now that most people in your fields are having these non-competes. So it's not going to scare people away from hiring you. You will need to disclose it, though, because if you don't disclose one and they get a cease and desist letter, they're likely to terminate at that point. Next slide. Entire agreement clause is also very important. This says, hey, this contract's the entire agreement. This is what happens when I get a call saying, oh, but in a separate email, they promised me that I'd get this bonus, but it's not in the contract. Guess what? That email is not enforceable, because you agreed that this contract is your entire agreement. It's in pretty much every single contract, and is, again, one of the most litigated issues, because people come in and say, but they promised this, they promised that, they told me they'd do this. And when you sign something saying this is the entire agreement, it supersedes any other agreements, you just nullified any email agreements, handshake agreements you have. So pay attention. It's in almost every single employment contract we see. Next slide. There'll be a clause in there for independent legal advice. Something their lawyers on the other side advised, saying, hey, go get a lawyer. What they're trying to do is keep you from being able to say, oh, I didn't know what I was signing. I signed under duress. So it's in their interest to say, go get a lawyer, because then, if you come back and say duress, they get to say, but we told them to go get a lawyer. So that's what that means. They're encouraging you to get legal advice. Next slide. Severability. Again, this is that legalese at the end of the contract that everyone just skims over, doesn't pay attention to. It simply means if one part isn't going to be upheld, the rest of the contract stays in place. Very common. That's almost always what it says, right? So if the non-compete gets struck, everything else stays in place. So that will be in almost everyone. Most people have no idea what it means. That's what it means when you agree to it, that if any part of it is struck, the rest will stay enforceable. Next slide. Amendments and modifications. This is important. They will spell out how you can amend your employment contract, right? So say, for example, you're doing great one year and they say, you know what, we're going to increase your salary triple from what it was, triple your raise of what it was supposed to be, but it's all done in writing and your contract has a specific salary. And then later something goes wrong and you're saying, wait a minute, why is my severance being paid out at the old salary instead of my current salary? The amendments clause tells you what you have to do to change the contract. And usually it will require a writing signed by both parties. So if you have a handshake agreement that changes something in your contract to your favor, again, you can handle it very professionally and say, oh, thank you so much. I'm excited. I just noticed this in the contract. So I just want to make sure I'm doing what I need to do. I drafted something we both need to sign for it. It will protect you in the end if something goes wrong, that you amended it by the way the contract requires you to do it. Next slide. All right, we're going to spend a number of slides talking about non-competes. This is a very hot topic. We get a ton of non-compete litigation. Right now, there is a proposed rule from the FTC to eliminate all non-competes. It has not passed yet, but there is talk of that. You'll hear it out there. So we're going to be listening for that in the future. But right now, in most states, non-competes are allowed. There are a few that they are not, California most notably. So watch it. These are, again, heavily litigated. There's different types of them. A non-compete in its pure form says you cannot take another job that competes against our business. Then there's the kind of non-solicitation clauses where you say, I won't solicit any clients of yours, or I won't solicit any employees of yours to another business, I'm not going to take any of your vendors if you have a specific vendor relationship. So there's non-competes and non-solicitation. So know what you're dealing with. They're very different, right? Non-competes, you couldn't even go to a place even if you weren't going to solicit employees or clients, whereas non-solicitations, you can go work wherever you want. If that's all you have, you just can't bring on employees, or you can't solicit clients that you used to have. Next slide. So courts will look at them very carefully in almost every state where they're allowed. It is not just a free-for-all where you can say you can't compete ever. They have to meet a number of requirements, for them to be upheld by a court. And like I said, I look at a lot of them that won't be upheld. And they recognize that people have a right to earn a livelihood. And it hurts it hurts the consumer, right? I litigated, I had a 2-month trial for an oncologist who was one of the only ones who could do certain types of surgeries, cancer-related surgeries. And when his non-compete went into effect, it meant people from Maryland had to travel to Southern Virginia to get the surgery. That alone was a good argument to get him out of his non-compete, because there is such an importance on your right to go out and work, and on consumers' rights to go out and be able to have doctors and engineers out there in the economy. Next slide. So what do courts look at when they say, are we going to enforce this agreement? It has to be a protectable interest, right? So say, for example, you work for a company it's a stupid example, but I'll use it. A company that makes hamburgers and hot dogs, and you never worked on the hot dog side. You only worked on selling hamburgers, but then the non-compete says you can't work anywhere that does hamburgers or hot dogs. They have no interest on the other side that you never worked in. You didn't get any trade secrets over there. You didn't get any customer contact on that side of the business. It has to be something that they have a real interest in, right? They can't just forbid you from going out and competing in something they don't do, or in some part of their business that you had no access to. That's not a legitimate reason to protect their business. It has to be reasonable in scope and duration. We're going to talk about this a little bit more in future slides. Scope meaning how long is it? I'm aware of one opinion out there that upholds 3 years. Generally, they top out around 2 years. There are some states that will allow 3. And geography, right? Can they forbid you from the whole world? I see a lot that narrow it down to 10 miles that said if you're going to be CEO of a company and have contact all over the place. There is a case, not out of Maryland, but out of Connecticut, that held up an entire countrywide non-compete because he was a very well-paid CEO who had contacts in every state. But they're going to look at it. Where were your contacts? Where were you providing the work? Can you still make a living for yourself? They're going to look carefully at that geography. Is it harmful to the general public? Again, if you're removing the one surgeon in a 50-mile radius who can do a certain surgery, they're going to look at that and say you can't do it. Is it unreasonably burdensome to the employee? Does it require the employee to move to find another job? That's going to be unreasonably burdensome and not be upheld. Next slide. So I mentioned you have to have a protectable interest. What is protectable? Your trade secrets as an employer? Absolutely. Customer information, right? Customer preferences. So say you worked on a project management as an engineer, government contract, and you know everything that government customer likes you know everything about the pricing, how they like to order, and you take that knowledge somewhere else and use it to compete, that's going to be a protected interest. Software, for those of you developing software, that is going to be a protectable interest. IP that you develop on the company's dime that they own, that will be protected in a non-compete. Goodwill, you know, the name of the business, that is a protectable interest. If you wanting to move, if something could damage the goodwill of the business, they're going to uphold it. Unique or extraordinary services. This is not that common, and I think I've seen it once in 24 years of practicing. But they can say, you know, if you have unique or extraordinary services, they may protect the employer a little bit more than they otherwise would. Next slide. Soliciting employees. Essentially, that's where you're saying, hey, like my company's hiring, come over here. If you sign a non-solicitation, you need to stay away from bringing employees on board. And in fact, even be careful on your social media. We're getting social media cases where somebody posts on their Facebook about their company hiring, and they have 40 or 50 people from their last company on there, and they're getting cease and desist letters. Copyright, tortious interference claims. So tortious interference is how they come after the employer, that the new employer is interfering with their contractual relationship with you not to compete by giving you a job. And that's how they sue the deeper pockets of your new employer. So they do get dragged into it. Copyrights, things like that, very protected for employers. And if they think that you're going to use anything that's copyrighted, you know, then the court is going to uphold, you know, those non-competes. Next slide. So we talked a little bit about how it has to be reasonable in scope for geography and time. As I note in the slide, there's no hard and fast rules. You get there by going into the state that you agreed to have govern your relationship. If you didn't agree to a state, it's where you're performing the work. Geography, again, it has to be reasonable. If you won't be able to get another job without moving, it's not reasonable. If you are being held not to work in the entire DC, Maryland, and Virginia area, but you only had contacts in one county, that's not going to be reasonable. Timing, again, we see them tapping out about 2 years, 3 years is a very high end of it, and common to see them lower than that. You know, so if you get one for 5 years, I saw one last week, and you know, that's not going to be enforceable. If it's the whole country and you don't have contacts across the country, that's not going to be upheld either. Next slide. So I've given some examples here just so you can get an idea. 2 years, don't work with any customers, valid and reasonable by the case law. That's a pretty easy one. I would look at that and say, yeah, you're not going to get out of that. Another one, 2 years, you can't do any activities with manufacturers represented by the former employer. Again, you know, it's specifically tied to people that, you know, they were working with. 2 years, that was held enforceable. Next slide. A whole bunch of examples here. 45-mile radius for 5 years, got modified to a 3-year duration. So the issue here was that 5 years got modified. We'll talk a little bit about the court's ability to modify it. They can do that in certain states. It's called blue penciling, and the judge doesn't throw it out, but instead can rewrite it to be enforceable. 5 years. On the next one, unlimited to area. If there's no geographic limitation and it's 5 years, that's a no-brainer. That's just not going to get upheld. Here's one with 2 years that wasn't upheld because they were looking at how long, you know, how long the employee might still be acquainted with the existing customers, finding that the customer base wouldn't still be acquainted with that person after, you know, after that time period. You know, other examples, indefinite dates, things like that. So these just give you some ideas of how you see this playing out, and obvious ones that when I would look at this, I'd say there's no way they're going to enforce this. Next slide. So in looking at the reasonableness, here's some of the stuff they take into account. This happens all the time where they say you can't solicit prospective customers. Courts look at that with a lot of scrutiny. You don't even know who they are. So how can you know whether you're violating if you have no idea who a prospective customer is? If they're not specified, that's going to get a lot of critical review from a court. They do take into consideration whether you were fired or quit. It's definitely not determinative. A lot of people come to me and say, hey, I got fired. I shouldn't be held to this. Nope, they're still enforceable even when you're fired. But if it's a close call, they do look at that as a factor, and you'll see case law weighing that. They look again at the employer bargained in good faith, right? The employer who says the whole world for 5 years, that's not going to be looked at very well by a court, and they're probably not going to want to do a lot to save that employer. Again, trade secrets comes up over and over. That's what's really going to be protected by the courts. Unskilled workers. This is under attack in almost every state. Maryland passed legislation a couple of years ago. If you make less than $15 an hour, you cannot be subject to a non-compete. DC has a version of this. And it's under attack everywhere. If you're somebody whose services are not unique, and you haven't invested in a lot of education, those likely won't be upheld. They do look at if the employer invested a lot in publicizing you, they will look at that as something to protect for the employer. Next slide. Again, it can't be unduly burdensome to you. If it completely restrains you from going out there and doing what you know how to do, it is not going to be upheld. Next slide. There has to be consideration. That means that in a contract, each side has to give something up to get something in return. If not, it's considered a gift, right? So each side is giving something of value for it to be enforceable. Most states hold that continued employment is enough for a non-compete. So if you sign a non-compete and you get fired the next day, talk to a lawyer. That's probably not enough continued employment for it to uphold that non-compete. It has to be a substantial period of time afterwards. There's a Maryland court case for 3 months saying it's not enough. How much more they'd uphold in Maryland, I don't know, but that's similar in many, many states. I mentioned the duress defense. It doesn't work. It's why I have it here. I can't tell you how many people call and say, I was told I couldn't have a job unless I signed this. And the courts will say, that's completely fine. They can require it as part of your job. So that duress defense that I had to sign it to have a job doesn't work, unfortunately. Next slide. Blue penciling, I mentioned this. Courts in some states, including Maryland, have the ability to go in and rewrite parts of the contract. If it's 5 years, they could make it 3 years. If it's 20 miles, they could change it to 10 miles. So, keep that in mind, because a lot of people come in and say, well, it's just going to get thrown out, so I'm not going to care at all. Courts have that ability to do it. They don't always exercise it. Sometimes they think, companies, in fact, there's a federal opinion not too long ago in Maryland that said, I'm just protecting bad faith employers who are writing overbroad agreements to scare their employees, so I won't blue pencil and save them from this overbroad agreement. But it's a possibility, so know that's out there. Next slide. So what happens if you breach, right? And by this, for example, say you have a 1-year term and you get the job opportunity of a lifetime, you can't resist it. You're going to just leave the employment before your term is up. It really depends on what the contract says. Some people have to pay back moving expenses. I have a case in the office right now where somebody's dealing with a tuition payback of tens of thousands of dollars. So take a look at what you're agreeing to, moving expenses. I get these calls all the time where somebody's like, this place is horrible. I can't work here another day, but I got $40,000 in moving expenses that I use to move, so I don't have it sitting around, that you'd have to give back if you breach the agreement. So take a really close look at what you're agreeing to. And if you breach, what are they going to be able to argue are the damages, right? Hey, you breached, we invested X number of dollars in training you, things like that. So be really careful to be looking at those things, because a lot of people leave and they're not looking, oh my gosh, now I owe 40,000 of moving expenses or 80,000 of tuition reimbursements back to you. And that is a very common issue. We see a lot of just $10,000 liquidated damages clauses for leaving during a term where, that's your buyout provision to get out from under it. So take a close look. It's not a static world. It's dynamic, and know what you need to know before you sign it, because moving around can have consequences when you have agreements like this. Next slide. Keep a signed copy. The vast majority, I have somebody came to me a couple of weeks ago with a $6 million employment contract, and he didn't keep a signed copy. And it has edits written in it that I don't think it's the final version, and he doesn't think he has a copy of it. By the time you are searching for that and talking to a lawyer, it is probably already hostile. Keep a signed copy. You want to be able to go back and look. What are my obligations if I leave? If there's a dispute over your severance, get the signed copy. You don't want to dispute as to whether or not this was the last version or a draft version. Get a signed copy. Next slide. When to get a lawyer. I will say almost always I find things from the beginning in negotiating a contract that I think are very helpful to people. So I think having a lawyer look at it from the beginning, just to avoid onerous clauses. I see a lot of, employee agrees to pay all of our legal expenses if we have a dispute. That sounds outrageous, but it's in about half of them out there. It can make sense to get a lawyer right away, right? To negotiate your way out of some of those, at least know what you're getting into. But certainly if you have a severance provision and you see them starting to try to document cause in a way that would get you out of your severance, talk to a lawyer. It's a very common thing where, if we have cause, we can save ourselves $100,000 of our department's budget by not paying severance here. So let's start writing the person up. Definitely do that. If you're thinking of leaving before your term, definitely talk to a lawyer. So it's a good idea, in a proactive way, but certainly when things take a bad turn or you want to go to a new opportunity and you're worried about the non-compete, always good to talk to a lawyer. They can do things to help you protect yourself. If you're a close call on the non-compete, there's certain prophylactic measures you and the new employer can take. So good idea to talk to a lawyer when you're making a move, if things go bad. And frankly, most lawyers don't charge a lot to do a simple contract review. My office does them all the time. Most of the time, I think it's worth it. It's pretty rare I see a contract and say, this is good, you're good, go sign it. Usually I have some edits where they're just very one-sided in favor of employers, because again, most people sign because they want the job. Next slide. That's it. And if I timed this right, I have left 5 minutes for questions. So, so happy to answer any questions anybody has. My information is here too. From this session, I always get some fun emails afterwards. I get a lot of immigration type questions. That's not my focus, but I do know how it interacts with employment laws and contracts. So if there are any questions, happy to answer them. If it's something more substantive, feel free to shoot me an email or call my office. I'm always happy to help the students here. Any questions?
All right, folks, don't be shy. We want to hear from you.
I think this will be a record for the first time ever. Usually we get a lot of very dense, specific questions to this one.
Right. And yes, the recording will be posted on our website, and it will be sent out by email along with the slides to everyone who registered. Quiet group today. I guess folks are just waiting for those contracts to come in. They haven't received them yet.
I have a question.
All right,
I'm wondering if you are in the, at the beginning when you receive the contract and you want to take the time to review it with a lawyer, what would be do you have like good phrase to sort of say, like something prepared to have in mind to the employer? How much time is reasonable to, get back to them?
Yeah, that's a great question. So most of the time, there's going to be a clause in there saying we've encouraged you to get independent legal review. So I tell employees, point to that, right? Say like, oh, I saw this clause that you've encouraged, so I want to be sure I do this right. Because usually it's their suggestion, and you can say like, oh, I saw your suggestion, so I'll do that. So that it's not like, oh, I'm lawyering up already. Oh no, it was your suggestion. So that's a good way to do it. And I do this all the time, but I always say it's timeline, blame the lawyers, right? Like I say it all the time, blame me. I'm out here. If the other side hates me, that's probably good. And you're the nice person. So say, oh, you know what? I need 4 days, 5 days. You should see these lawyers' schedules. I can't get on a calendar, right? So for timeline, it's probably going to be dictated by how quickly you can get a lawyer to look at it. And in the emails where you're managing it, saying, hey, I do want to follow your advice, but these lawyers, I can't get on their schedules, so that you're, again, the good employee following their advice. And I would have done this yesterday if it weren't for these terrible lawyers' schedules. So that's a good way to sort of introduce the topic of having a lawyer review it.
Thank you. I appreciate that.
Sure.
We do have another
question. Oh, sorry, Michael. I didn't know.
No,
if you
go
saw
ahead.
it. Go ahead.
in the chat from Robin. We have a question. What are some items people tend to negotiate when dealing with tenure track positions? And then they say like research funds, for example, moving expenses, etc.
Yeah, so I do find, first of all, the tenure positions tend to be tougher to negotiate because there's so many comparators, and they're worried about treating one person more favorably than the other. And so it's an interesting dynamic, because usually there's a powerful, valuable person wanting to negotiate for you. But at the same time, they don't want to change things and give you more. If you're tenure track, obviously there's going to be existing grievance policies and things that apply to tenured employees and tenured, professors. They're usually, if they have that whole plan, and almost every university does, they're not going to deviate from that in your contract. So that's one where your termination is going to be dictated by outside policies and procedures. Make sure you have a copy of it. For research, it is common to see research funding. It may be tied to research funding. Your termination, you may have a termination, that comes because you've lost research funding, where they reserve the right not to pay any severance because it wasn't their fault. They lost the research funding. If you're doing research, you better bet they're going to have a beefed up work for hire clause in there, so that they're owning all the research you do. So the biggest thing I would say is make sure you have all the outside documents on your grievance procedures. You're going to have very different grievance procedures that give you a lot more rights than regular employees. And that's where your rights are going to come from. So get your hands on that. And that work for hire clause is going to be super important, because they're going to claim everything you do belongs to them. So take a look at it. Make sure if you have something you were working on before as a student, that you carve that out in an exception to the work for hire.
Right, any other questions? Hey, it's quiet. Maybe everyone's working in California, where the rules are so favorable for employees of California.
Yeah, maybe
But
so.
if only.
Yeah.
But Joyce, as always, you've done a great job of preparing our students for these incoming job contracts. Thank you so much for a really thorough review of what folks need to be looking for. Cindy and Michael, thank you for hanging out in the background, and